agreements opposed to public policy. So, one example under this clause we have to discuss: A promises B to obtain employment in public services and B promises to pay rupees 1 lakh to A. So such agreement is void, as the very object and consideration of this are unlawful. So, how to define what is public policy? And regarding that, we will discuss one leading case of the Supreme Court, that is Central Inland Water Transport Corporation Limited versus Brajnath Ganguly, and that was of 1986, where the very apex court expressed that the Contract Act does not define the very expression public policy or opposed to public policy, so are incapable of precise definition public policy and contrary to public policy, or which is not defined under the Contract Act, and so it is not the policy of any particular government. It connotes some matters which concerns the public good, public interest, or public welfare. So, regarding the very definition, we'll go to that how the very doctrine of public policy was coined, and it was coined by Lord Halsbury in the leading case Jansen versus Dryad Fountain Consolidated Mines in 1902, and in another leading case of the apex court, and that is R.S. Debu versus M.B. Hindalkar, that was of 1995. The case was dealing with dry killing of a laundry, and where the very receipt was issued, and on the very back of the reverse portion of the receipt there was certain conditions which were mentioned by the dry cleaners, and it was held that the printed conditions was too wide, one-sided, and purported to restrict the liability of owner of the laundry arbitrarily and unreasonably, and it was opposed to public policy. So agreements may offend against public policy or trading with enemy, stifling prosecution, interference in the course of justice, and of champerty and maintenance. So, regarding that, we'll discuss one by one. When it is first one regarding trading with enemy. So, whenever there is an agreement in between two parties, and that agreement in nature of supply of arms and ammunitions, and it is totally void. Suppose take it an example in between those parties of India and Pakistan. So on commercial goods such as clothes or machines or consumer goods, and such agreements are not void, but they would be suspended and they could be revived after the end of war. So, if those two countries, such as India and Pakistan, they are in war, and during that period, agreements made regarding commercial goods would be suspended and it could be revived after the end of the war. But any agreements regarding the nature of supply of arms and ammunition between the parties are totally void. And the second one regarding stifling prosecution or suppressing any prosecution is itself void. For example, it is a kind of abuse of law. So, for example, A saw the murder of C by B, then the deal was made of arrest 10 lakh not to report it to the police. So, no charge sheet, no case was filed, and it suppressed the crime. So, this kind of agreement or compoundable offense, and such as the motor accidents which could be compromised by parties instead of going to court, whether such agreements are void or valid. Those compromise regarding such offences committed regarding motor accidents in between the parties instead of going to court to settle the matter in between them are valid. So, agreements on non-compoundable offences, as we have discussed in the first example on dealing of arms, ammunition, or suppressing any evidence of non-compoundable offences, as on dealing of drugs, arms, ammunition, are void. And now we'll go to the third one, that is interference in the course of justice. And regarding that, any bribe to judges, lawyers, public prosecutors, and even to influence the witnesses or hearing of murder case by judges. So, in all these cases, it would be considered as interference in the course of justice. So, for example, X was the accused. Y, on behalf of X, offered rupees 50 lakh for acquittal, either to the judge or to the lawyer, then it would be considered as an agreement of interference in the course of justice, and such bribe to even to witness not to appear in court on the regarding to change statement would be considered as interference in the course of justice.